Welcome to Focus Washington. My name is Chuck Conconi. My guest today is Brett Kappel, and you're an expert in lobbying and ethics at the law firm of Vorys, Seymour and Pease here in Washington, D.C. Brett, thanks for coming on to the show.
Glad to be here.
You know, the Obama administration has ignited what is a firestorm of protest on K Street over the public interest community over lobbying restrictions, particularly for stimulus funds. Explain a little bit about what's happening and why there is so much protest over that.
Well, what the Obama administration was trying to do was to ensure transparency and the accountability in the distribution of stimulus funds. The way they chose to do that, however, was to impose restrictions on lobbyists representing clients seeking those funds. And the thing that has been so controversial is that they actually prohibited lobbyists from orally speaking to any employee in the executive branch about a specific stimulus project. Lobbyists are allowed to submit written comments on specific projects, and those comments have to be posted on the agency's website within 3 days after they're received. But anyone who's a registered lobbyist under the Lobbying Disclosure Act is prohibited from attending any meetings where specific projects are discussed, or even talking on the phone with anyone in the executive branch who would be in charge of distributing these funds.
It's hard to understand the difference, and but who opposes this proposal? I mean, there's an unusual alliance of groups, I understand.
Yeah, it's a pretty broad swath of the public interest community and the business community that are opposed to it. On the right, you have the American League of Lobbyists and the American business community, which has been concerned about these restrictions on lobbyists. And on the left, you have groups like Citizens for Responsibility and Ethics in Washington, and even the Washington Post business editorial page opposed the scope of these restrictions.
Well, that's what I understand. It's touched a nerve among lobbyists, including groups that traditionally say restrict K Street more.
Right. I think there are actually two concerns. The business community and the lobbying community sees this particular restriction as perpetuating the view of lobbyists as all being Jack Abramoff types who are peddling influence and using undue influence to get a hold of federal funds. And they're also concerned, as I think the public interest groups are, that these particular restrictions aren't going to have the effect that was desired at the outset, because they don't cover all of the people who supposedly have undue influence, and they cover too many people who don't have any influence. And the way they're structured, it's too easy to evade these restrictions. You might wind up with less transparency rather than more. For example, rather than having the vice president of a company who's a registered lobbyist being able to speak to the member and have those comments be recorded, you have the CEO of the company. He's the one who's making the phone call now, but those comments aren't public and they're not posted on the website. And it may be the CEO that has more influence with the Obama administration than the vice president of government relations.
Well, you think the administration's move on this is really raises legitimate freedom to petition government First Amendment rights?
Well, it raises actually probably 5 different constitutional concerns, the most important of which are the First Amendment concerns, because it's a prior restraint on speech. Lobbyists can't even communicate orally at all. And that's very rare in American law, to have a prior restraint on speech. And it affects both the lobbyist and their clients. So both of them have a First Amendment right to petition the government, and both of them are having that right restricted by these requirements.
So it's an overreaction, so it is a threat.
Well, I think it's not narrowly tailored to achieve the result it wanted to achieve. The business community and the public interest community had proposed an alternative, which is to allow lobbyists to make these oral communications, but to make sure that everyone who's seeking these federal funds have their comments posted on each agency's website, so you can see what everyone is saying. So it would be the lobbyists and the CEOs and everyone. That way, that would ensure transparency and accountability, and it wouldn't raise these First Amendment concerns.
Well, there was a 60-day comment period that ended about a week or so ago, and there's no word from the administration. What happens next?
Well, I strongly suspect that if there are no changes made, that one or more of the groups who have opposed these requirements is going to file a lawsuit. And that would get very interesting very quickly, depending upon what type of legal tactics they want to take. I mean, for example, the most aggressive approach would be to seek a temporary restraining order to prevent the distribution of any stimulus funds until the First Amendment challenge was heard and decided by a court. that would be pretty aggressive. But in either event, I think you are going to see a court challenge, and I think it has a good chance of succeeding.
So it could be very effective, especially when you have groups that are so differing, like ACLU and the lobbying groups, getting together. I mean, this ought to be something that would be frightening to the Obama administration.
Well, it's certainly bipartisan, and you would think that a president who's a constitutional scholar would be a little concerned about having one of his first acts up for review so early in his administration.
Well, Brett, thank you so much for being here today. We'll be able to talk more about this, I'm sure. I'm Chuck Conconi, and this has been Focus Washington.